ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಸಿಎಂ ವಿರುದ್ಧದ ಮೂಡಾ ಕೇಸ್ ವಿಚಾರಣೆ ನಡೀತಾ ಇದೆ. ದೂರುದಾರ ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣ ಪರ ವಕೀಲ ರಾಘವನ್ ಅವರ ವಾದ ಮಂಡನೆ ಆಗ್ತಾ ಇರೋದು. ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಸಿಎಂ ವಿರುದ್ಧದ ಮೂಡಾ ಕೇಸ್ ವಿಚಾರಣೆ. ದೂರುದಾರ ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣ ಪರ ವಕೀಲ ರಾಘವನ್ ವಾದ ಮಂಡನೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಒಂದು ತಪ್ಪಾದ್ರೆ ಓಕೆ, ಪದೇ ಪದೇ ಆದ್ರೆ ಅದು ದುರುದ್ದೇಶ, ತನಿಖೆ ಅವಶ್ಯಕತೆ ಇದೆ. ರಾಘವನ್ ವಾದ ಮಂಡನೆ ಮಾಡಿದ್ದಾರೆ. ರಾಜ್ಯಪಾಲರ ನಿರ್ಧಾರ ಸರಿ ಇದೆ ಅಂತ ಹೇಳಿ ದೂರುದಾರರ ಪರ ವಕೀಲರ ವಾದ ಮಂಡನೆ. ಮೂಡಾ ಸೈಟ್ ಪಡೆಯುವಲ್ಲಿ ಅಧಿಕಾರ ಬಳಕೆ ಆರೋಪ ಕಾಣ್ತಾ ಇದೆ. ಸಿಎಂ ತಮ್ಮ ಪತ್ನಿಗೆ ಬೇಕಾದಂತೆ ನಿಯಮ ಬದಲಾಯಿಸಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ ವಾದ ಮಂಡನೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Kindly turn to paragraph number 11 and para 12. My lord, we are not, in the instant case, my lord, we are not concerned with either direction or sanction. We are only concerned with approval.
Yes.
My lord, kindly see para 11. In both the cases of sanction and direction, an application of mind is necessary. But there is an essential difference that in the one case, there is a legal impediment to the prosecution if there be no sanction. And in the other case, there is a positive order that the prosecution should be launched. For a sanction, all that is necessary for the one to be satisfied about is the existence of a prima facie case. In the case of direction, a further element that the accused deserves to be prosecuted is involved. Therefore, my lord, direction is at a higher pedestal, then your lordships have sanction, and then your lordships have the concept of approval.
Last 4 lines of that paragraph.
Yes, my lord. Whether sanction should be granted or not may conceivably depend upon consideration extraneous to the merits of the case. But where the prosecution is directed, it means that the authority who gives the direction is satisfied in his own mind that the case must be initiated. Sanction is in the nature of a permission, while a direction is in the nature of a command. Now, my lord, where does this come? This is neither a sanction, neither a direction, it is an approval.
Because
It is at the bottom of the pyramid. So therefore, if direction requires something more, it requires the highest element of application of mind, and then your lordships have the sanction and then approval. So, my lord, if we look at it that way, then, my lord, the standard required for the purpose of 17A is much less in rigor than for a sanction under 19. Now, my lord, please see para 12. Let us now examine some of the decisions on the subject. For the appellant, strong reliance was placed on the judgment of the Privy Council in so and so, and it was argued that on the basis of some of the observations of the Judicial Committee that a sanction was an important and substantial matter and not a mere formality. The facts in that case were that while there was a sanction of the government for prosecution under the Cotton, Cloth and Yarn Control Order, there was nothing in the sanction itself or in the shape of extraneous evidence to show that sanction was accorded after the relevant facts were placed before the sanctioning authority. To quote the lordship's own words, there is no evidence to show that the report of the sub-inspector to the district superintendent of police, etc. I'm going to skip that. Prosecution was in a position either to produce or to account for the absence of the report made to the district superintendent of police and the endorsement of the district magistrate referred to in the sanction. It is in this connection that their lordships emphasize that sanction to prosecute is an important step constituting a condition precedent and observe, looked at as a matter of substance, it is plain that the government cannot adequately discharge the obligation of deciding whether to give or withhold a sanction without a knowledge of the facts of the case. Nor in the lordship's view is a sanction given without reference to the facts constituting the offence a compliance with the actual terms of clause 23. This, however, is no authority for the position that a sanction stands on the same footing as a direction. Therefore, sanction is different from direction. It is true that the facts should be known to the sanctioning authority, but it is not at all necessary that the authority should embark also on an investigation of the facts, deep or perfunctory, before according sanction. Your lordship may mark that, my lord. Even a deep or a perfunctory, he need not do it. The decision lends no support to the view that wherever there is a sanction, the sanctioning authority is disabled under section 556 of the code from trying the case initiated as a result of the sanction. On the other hand, there is plenty of support for the opposite view.
Yes.
Now, my lord, having shown to your lordship this, may I now request your lordship to take my compilation of judgments, my lord. I'm not going to show to your lordships, take your lordship through all this, because in our submission that we have made, we have extracted the relevant paragraphs, my lord. Though I must tell your lordships, my lord, that it appears, my lord, that the government in England appointed a commission to go into the merits and demerits of oral arguments in courts and written argument that is prevails, my lord, in the United States. And the report of the commission was a meaningful shrug of the shoulders of a Queen's Counsel is worth 100 pages of written arguments.
Yes, sir.
But I know, my lord, but
All right. Yes.
I'll leave it. I have given your lordships the extracts of the paragraphs, which, my lord, will not have
We'll harmonize the two.
harmonize the two, and your lordships may read that, my lord. But having said that, I want to point out your lordships one thing. Now, my lord, kindly look at the scope of 17A, which your lordships have looked at in several cases.
Hmm.
Lord, your lordships have seen Ashok's case, which is your lordship's judgment. I'm not going to detain your lordships on that. But then, my lord, before the judgment in Ashok came, there was another judgment of your lordships in Sri Rupa,
Yes.
which, my lord, your lordship will find is at page 496, which is in volume 2. Please look at it for a minute. I'm just going to show to your lordships for a different purpose. I know, my lord, your lordships have authored the judgment.
Yes.
Kindly see paragraph number 11. What was it? What was the aspect which prevailed upon this honorable court to hold, my lord, that the sanction was not, that the sanction was not enough?
Approval.
No, it just said ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ ಅಷ್ಟೇ.
ಅಷ್ಟಕ್ಕೆ ಅದಕ್ಕೋಸ್ಕರ ಬರೆದಿದ್ದು.
ಅದಕ್ಕೋಸ್ಕರ, exactly. Exactly. Now, this aspect of the matter, I only wanted to point out, your lordship, that particular fact which your lordships have not seen. This aspect of the matter, my lord, was looked at again by another coordinate bench of this court.
Yes, when it came again,
Yes.
there it is held that it stands on a different footing.
Yes, yes, yes.
Because it was 19 then.
No, 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 no.
It is not 19.
No,
is
no,
it?
no, ಅದು 17 ಏನೆ.
ಮತ್ತೆ
ಹೌದು ಇಲ್ಲ ತಾವು ಕಳ್ಸಿದ ಮೇಲೆ ತಿರ್ಗಾ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಓ ತಿರ್ಗಾ
your lordship may look at that, my lord, which is at page 510. My lord, that is the judgment of his lordship Justice Sanjay Gowda.
Yes.
Please be kind enough to turn, my lord. There your lordship may kindly see, my lord, how it has been distinguished. And that is why, my lord, my respectful submission to your lordship will be, do not apply the approach that your lordships adopted in Ashok's case. My lord, please be kind enough to turn.
Para 29 to 31.
My lord, please see para 33, my lord. I want
33
your
is
lordship
the
to kindly
finding.
see. 33.
But 31 is what is said.
My lord, what is relevant in not actually is para 39 to 49.
All right.
But please see para 33 for a minute.
Yes, sir.
At page 516. Section 17A of the Act is drafted with the overarching objective of ensuring that unnecessary investigations against public servants are prevented, and the state government is required to take a decision to accord or refuse approval to conduct an investigation within a time frame. This indicates the balance that the law intended to strike in the manner of an investigation being conducted against a public servant. Now, my lord, please be kind enough to turn to paragraph number 36. I'm going to skip 34 and 35. At this stage, the stark and striking difference.
No, there it was again elaborate. That's why 49, my order is quoted. 51, it is said it is, it bears application of mine, dismissed.
In fact, your lordship's order is quoted, and my lord, the learned judge holds because of that ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ was the only ground. But then, my lord, the law is explained further. Now, my lord, just look at para 40. I'm going to skip a few paragraphs, my lord, though I thought it's relevant, but summary is there. To summarize, the law has conferred a twofold protection vis-a-vis a public servant for offences under the Act. The first layer of protection is even before an investigation is conducted, where a prior approval is needed under Section 17A of the Act. The second layer of protection is after completion of investigation, where sanction to prosecute the public servant is required under Section 19. It is clear from the statutory framework the legislature has decided to not only protect public servants from unwanted investigation, but also from a prosecution by making it mandatory for the investigating officer to obtain two different and separate approvals for investigation and for prosecution. It should also not be forgotten that merely because an approval is accorded to conduct an investigation, investigating officer cannot proceed to prosecute the public servant, and he is still required to obtain prior sanction of the government to prosecute the public servant under section 19. Then, my lord, your lordship may kindly turn to paragraph number 47.
Caesar's wife
My lord,
must be above suspicion.
yes. And now, my lord, no, my lord, that's after those few lines. The integrity of a public servant is required to be beyond suspicion, as in the proverbial adage, the Caesar's wife must be above suspicion. If there exists even a shadow of doubt on the integrity of the public servant, it will not only harm his reputation, but will also tarnish the entire system of which he is a part. Thus, in such a situation, if the aspersions cast on the integrity of a public servant and an investigating officer under the Act harbors a view that an investigation is necessary, it would be in the interest of both the government and the public servant that such a nagging suspicion is obliterated. So, my lord, the word emphasizes nagging suspicion. Is it there or not in this case? That's all the inquiry. Some element of discomfort is enough. Unless you're not with that, nothing. I'm so comfortable with what's happened.
Lurking suspicion.
Lurking suspicion is a nagging suspicion.
Nagging.
Anyway, my lord, that's the wording that his lordship has used now. In order to achieve this objective, therefore, the government should be given the greatest degree of latitude to accord approval for conducting investigation. So this is the approach, my lord. This is what I mentioned to your lordship at the beginning of my submission. Approach must be, if there is some suspicion, allow the investigation to take place. Do not scuttle it at the very start. Then, my lord, the contention, therefore, that the material furnished by the investigating officer is required to be subjected to a microscopic examination before according approval to investigate a public servant, as suggested by learned senior counsel appearing for the petitioner, does not merit acceptance. As stated earlier, before seeking approval under 17A of the Act, the investigating officer would only have to form a tentative opinion to determine as to whether an investigation is warranted or not, having regard to the material, credible information in his possession at that point of time. It may so happen that after conducting an investigation, investigating officer may very well come to the conclusion that there is no justification for initiating prosecution and may drop such proceeding against the public servant. Thus, the mere grant of approval to conduct investigation would not lead to an inference that the investigation would necessarily culminate in a prosecution against the public servant. And then, my lord, the judgment of this honorable court in Ashok's case is cited. And this earlier Sri Rupa's case. The argument that the materials collected have to be considered meticulously, as indicated by this court in WP number so and so, cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case, where the order of approval merely stated that the government had meticulously considered the matter by use of the term kulankashavagi parisharisaragi. The relevant portion of the order reads as follows, my lord. Then, my lord, para 52. In my view, this indicates that the state has applied its mind to the request made by the investigating officer and has considered the matter rationally before according its approval to investigate the petitioner and another. In the light of the distinguishing feature, the decision relied upon the learned counsel for the petitioner in WP number so and so in support that cannot be of any.
So let governor has applied his mind. In
My
this.
lord?
You want to,
Yes.
you want to paraphrase that? Yes.
Yes, my lord. This is-
Governor has applied
Yes,
his mind.
correct. Yeah, absolutely, my lord. That's, and I want to show to your lord, I wanted to show to your lordship, which I believe I have done, to say what was the basis on which your lordship's judgment in that
No,
case
that's
was
Sri
made.
Rupa, I am aware.
That's all. That's all. And I wanted to show to your lordship that this is the, and there's another view that has been taken by this honorable court, another coordinate bench. Your lordship may kindly see, my lord, though it arises under 156.3. Please see, my lord, page 522. My lord, kindly turn to paragraph number 48 at 536.
Yes, this I have.
But these judgments support the proposition that I am placing for your lordship's consideration, that it should be looked at in a very broad manner, especially having regard to those words relatable to and not commission of or recommendation by. Those words are not there. It is relatable to. In the context of a contractual clause, the Honorable Supreme Court has held, my lord, that these words relating to in regard to, in relation to, are words of widest amplitude. ಇದೆಯಾ? General Electric. Renu sir. Though, my lord, it arose in the context of the interpretation of a contractual clause, I would say, my lord, the same principle applies when your lordships are interpreting this. My lord, please be kind enough to turn to paragraph 25 of the judgment of the Honorable Supreme Court, my lord, in Renu Sagar.
You want term relatable?
Yes. What is the meaning of this word relatable? How do you understand it? What is so special in law when you use this word relatable?
Paragraph.
My lord, paragraph 25.
It's not part of compilation.
Avaru kottidira copy?
Yes, yes, yes.